Mr. Ohamo, is parties present? Defendants have them.
The claimant will soon join.
That means for now she's absent. Parties absent, my lord.
Yes, Mr.
May please, my lord.
Yes.
CM Ohamo, my appearance is for the claimant.
Okay. So this is my judgment. Yes, the claimant commenced this suit by way of complaint and other accompanying processes filed on 25th of February 2022 and asked for the following reliefs as contained in the statement of fact against the defendant. Number one, an order that the defendant remit into the claimant's ARM pension retirement savings account the sum of 680,045 naira being unremitted pension. Number two, an order that the defendant pay the claimant the sum of 619,446 naira being outstanding salaries from April to December 2011 and January to December 2012. Number two, an order that the sum of 40,250 naira be paid to the claimant being the sum for the claimant's outstanding transport to hotel accommodation allowance for training in Port Harcourt on 24th of August 2015. Number four, general damage in the sum of 500,000 naira for the financial hardship the claimant suffered as a result of the dependent actions. Number five, cost of the action assessed at 300,000 naira. The defendant did not file a memorandum of appearance, not to talk of statement of defense, but was on the 25th of October 2022 represented by one E.O. Pipa as counsel who appeared for the defendant. From the pleading filed by the claimant and her testimony, she was employed by the defendant on the 15th of May 2006 as senior secretary 2 on a salary of 3,000 naira, and her employment was confirmed on 24th of July 2007. Survived by the claimant that she worked diligently for the defendant and was promoted to the position of superintendent effective from 1st July 2014. That in all, she worked for 10 years before her appointment was terminated. Claimant averred also that her salary was paid in piecemeal from April to December 2011 and January to December 2016, and that there was a huge backlog of salary arrears being owed the claimant. The defendant also deducted pension from the claimant's salary but refused to remit same to a pension fund account. According to the claimant, the defendant did not also pay the sum of 40,250,000 naira being outstanding transport to accommodation allowance for a training she attended in Port Harcourt, which was duly approved by the defendant. Trial commenced on the 3rd of February 2022, where the claimant CW1 testified and adopted her statement on oath dated 25th February 2022 and tendered the following documents as exhibit: letter of appointment exhibits DC1, confirmation letter exhibit DC2, regularization of position exhibit DC3, change of name exhibit DC4, NECO insurance payslip exhibit DC5, official travel allowance form exhibit DC6A and B, letter of reorganization and restructuring exhibit DC7, EcoBank statement of account exhibit DC8, ARM pension retirement savings account statement exhibit DC9, letter of appeal for legal assistance exhibit DC10, letter of invitation exhibit DC11, letter of reminder exhibit DC12. The matter was adjourned for cross-examination of the claimant and possible defense, but neither the defendant nor its counsel was in court. The right of the defendant to cross-examine CW1 and defend the action was foreclosed on the application of the claimant's counsel, and the matter was then adjourned for adoption of final written addresses after the discharge of CW1. However, the defendant did not file any final written address, but the claimant did. Claimant final written address. Claimant's final written address, which is dated and filed on the 6th of June 2022, contains one issue for determination to it, and I quote, whether the claimant is entitled to the reliefs sought. The submission of a counsel that the first relief sought by the claimant as outstanding balance for a pension remittance is proved by paragraph 12 of a statement of fact and are evidence in paragraph 13 of the witness statement on oath. Claimant also referred to her ARM pension statement, Exhibit 9, in proof of that relief, and that the defendant was grossly negligent in remitting pension deducted from her salary, including the counterpart pension. That by Exhibit DC7, the defendant stated that the claimant's pension would be remitted, but 6 years after Exhibit DC7, nothing has been done by the defendant to make such payment. For the second relief sought by the claimant, being the accrued outstanding salaries, it was also submitted that Exhibit DC8 and the pay slips show the monthly salary of the claimant and the shortfalls, and there is unchallenged evidence that the defendant is owing the claimant the sums contained in the said relief. Counsel contended that it is unconscionable for a worker who has worked to be owed his wages for no just reasons, such in the case of Idigbe and Tetrazini, First Limited. That payment of wages is an essential ingredient of a contract, and where wages and other allowances stipulated in the contract of employment are not paid, then the employer is in breach of the contract. Counsel also contended on the third relief sought by the claimant that she tendered Exhibit DC6, which is the approved memo for a travel and accommodation allowance, which was not denied by the defendant. The counsel submitted that the claimant is entitled to damages and costs of this action, citing the case of Elotin and Mbadue. It was further argued that the defendant terminated the employment of the claimant in 2016, but still refused to pay the arrears of the salaries owed and consistently defaulted in remitting her pension. Counsel first submitted that the claimant should be entitled to the cost of this action, as she should not have incurred the expenses of coming to court, but for the action of the defendant. According to the counsel, the claimant has proved her claim as her evidence remained uncontradicted by the defendant. It is contended that although failure to call evidence in defense of the claim does not mean automatic victory for the claimant, because the claimant must succeed on the strength of his own case and not rely on the weakness of the defense. But the law is settled that the effect of a party's failure to call evidence in defense of a claim against him is that he is presumed to have admitted the case made against him by the other party, and a trial court has little or no choice than to accept the unchallenged and uncontroverted case placed before it by the claimant, citing the case of Amakri and INEC, Ifeta and SPDC, and Ogunyadi and Oshinke. The counsel finally submitted that the claimant has discharged the evidential burden placed on her, as she has been able to prove her case in accordance with the law. Court's decision. Upon careful perusal of the pleading filed by the claimant, the evidence adduced, and submission of counsel, I shall, in the determination of this case, adopt the loan issue submitted by the claimant. The issue is thus, whether the claimant is entitled to the reliefs sought. It is the case of the claimant that she was employed by the defendant, confirmed and promoted to the position of a pretendant, that she had diligently worked for 10 years, but was terminated by the defendant without paying her arrears of salary and remitting pension deductions into her pension fund account. Claimant's employment confirmation and promotion letters were tendered as exhibits DC1, 2, and 3. Claimant has also tendered her payslips exhibit DC 5A and D, and her bank statement of account exhibit DC8 to show her paid and unpaid salaries. Similarly, exhibit DC6 is the memo approving the claimant's travel accommodation allowance for the training she attended, and Exhibit DC9 is the claimant retirement savings account. As it has earlier been noted in the judgment, the defendant did not file any defense with the claimant's case, nor appeared to cross-examine the claimant. But it was only once that a counsel appeared for the defendant, but never appeared again. It is instructive to state that without a statement of defense being filed by the defendant, the claims of the claimant claims of the claimant remain unchallenged. No one sets out to prove at the hearing what has not been challenged. See the case of Olale and Okelende, Shetima and Shetima. It is settled that where evidence given by the party to any proceedings was not challenged by the opposite party who had the opportunity to do so, it is always open to the court seize of the proceedings to act on the unchallenged evidence before it. Unchallenged and uncontradicted evidence ought to be accepted by the court as establishing the facts therein contained. See the case of Odulaja and Haddad, Nigeria Maritime Services Limited, and Alaji Bello Afolabi, Okiki and LPDC. In other words, the court is entitled to take as admitted all facts which have remained uncontradicted and unchallenged. It is also settled principle of law, therefore, that what is admitted requires no further proof. See the case of NNPC Pension Limited and Vita Construction Limited, Pina and Meangwa, Owena Mass Transport Limited, Okumbo, Jolasun, and Bamboy. Although the claimant's evidence remains unchallenged and uncontradicted and must be deemed admitted by the defendant, given that the defendant entered no defense in this matter, but that does not absolve the claimant from proving her case under the minimal evidence rule. See the case of LAMI and Data Processing Maintenance Services. Generally, in law, while the evidence is uncontradicted, the onus of proof is satisfied on a minimal proof, since there's nothing on the side of the scale. But minimal proof remains minimal and does not mean no proof. The failure on the part of the defendant to give evidence does not exonerate the plaintiff from proving his case, though minimally, an expression that means as little as possible or very little. Going by the facts and evidence put forward by the claimant as to a claim for non-remittance of her pension deduction and a raise of her monthly salaries, as well as her outstanding travel to accommodation allowance, coupled with the fact that there's no defense from the side of the defendant, I am satisfied that the claimant has been able to prove her case on a minimal proof, hence the claimant is entitled to her claims. It can be observed that the claimant has in her fourth and fifth reliefs asked for general damage and cost of this action for the hardship she suffered as a result of the defendant's action. And I must say here that the claimant who was terminated in 2016 does not need to go through all this trauma just to get her unpaid salaries and pension deductions. Going by this, I think the claimant should be entitled to compensation and cost of this action. On the whole, and for the reasons given above, the claimant's case succeeds, and for the avoidance of doubt, I hereby grant the following orders. Number one, an order that the defendant remit into the claimant's ARM pension retirement savings account the sum of 680,045 naira, being an unremitted pension. Number two, an order that the defendant pay the claimant the sum of 619,446 naira, being outstanding salaries from April to December 2011 and January to December 2012. Number three, an order that the sum of 40,250 naira be paid to the claimant, being the sum for the claimant's outstanding transport to hotel accommodation allowance for training in Port Harcourt on 24th of August 2015. Number four, the defendant shall pay the claimant the sum of 300,000 naira general damages and 100,000 naira as cost of this action. Number 5, that the above sums shall attract 10% simple interest per annum until they are fully liquidated. Yes. Yes. Yes.
Mr. Amo, are you still there?
It's muted. Yes. Yes, you are muted.
Okay, my lord, I'm sorry, I didn't know it was muted. I'm grateful for the judgment of the court.
Thank you.
And I also start to wish my lord happy holidays.
Thank you.
And before the court again on the 16th for another judgment, then by the grace of God, I will wish my lord finally happy Christmas for the year.
Okay, thank you so much.
Thank you, my lord. Yes.
Thank you.
Thank you, my lord.
Thank you. You're welcome. Aja. Aja.
Sir.
Aja.
Sir,
Aja,
sir. Yes, that's all for today.
Okay.
So until next week Friday again.
Yes, that's the virtual hearing, ma.
Yes, my lord.
Yes.
But on Monday we'll be meeting, ma.
And we have physical meeting throughout the week.
Okay. So, Mr. Ohamwa.
My lord.
That will be all for today. I wish you a nice weekend.
Thank you, my lord. So I wish you too, sir.
Thank you, and bye for now. Aja, bye-bye.
Okay, bye, sir.
Thank you.